Mr. Newland, over the past 10 years, do you know how many leases the department has approved under the Long-Term Leasing Act that were for a period of up to 99 years?
I don't, Madam Chair, but we'll be happy to follow up with an answer to that.
But you are aware that there have been some?
Yes.
Okay. From your experience and professional knowledge, have these leases been beneficial to the tribes?
On the whole, I believe so, yes.
Good. And how has the BIA supported efforts for tribal leaders to have longer-term leases?
We have, 10 years ago, reformed the BIA's leasing regulations to try to make that process faster. And I believe that has been successful and provide more deference to tribes in making decisions about leases, both in terms of compensation and term, as well as implementing the Hearth Act, which we're almost to 100 tribes that have taken over the leasing under tribal law. And we try to get those requests approved expeditiously so that we're not interfering with tribal land use decisions.
Now, you have voiced some concerns about HR 1532, and you've mentioned that you believe that there were potentially unintended consequences, and that's in relation to how this particular act would play out against the existing case law. Is that correct?
Yes, Madam Chair.
Is there anything beyond your concern about the interrelationship between this act and the long history of case law that we have?
Not at this time. What I can add, if you like, Madam Chair, is I don't dispute, and the department doesn't dispute that the issues raised by the tribal leaders on the panel are real, because I've experienced those myself. The issue is not the law. The law as it exists right now allows tribes to purchase and sell fee land for business purposes, home sites. That already exists. The issue is the lack of understanding of the law by some of these lending institutions and title insurance companies. And you know, we're happy to, again, continue this discussion and assist tribes, as the Vice Chairman noted. But the law itself is not the impediment. It's the company's lack of understanding of it.
Well, and that raises an interesting point, which is it isn't necessarily unusual for Congress to clarify a particular law to address those kinds of concerns. Isn't that right?
Correct.
Okay, and so I see the role of Congress that if there is confusion or there is something that needs to be addressed, because as you say, they just need to go and read the case law. I don't necessarily disagree with that. But if we have the opportunity to clarify something that is going to give our tribes the autonomy that they seek, don't you think that that could be beneficial?
I do, generally, Madam Chair. We see, again, just last year, the Supreme Court make decisions about the status of reservations in Indian land tenure, and it is all built upon the Non-Intercourse Act, which was one of the very first laws this Congress enacted to address the acquisition of Indian lands. And so much that we rely upon in Indian country rests on top of that law. And our concern is, if we pull the Jenga block out from the bottom row, we don't know how that affects everything else.
Well, Mr. Newland, could I request a commitment from you to work with us to address what some of those concerns may be so that we can clarify and make this easier and better for our tribes to be able to have the autonomy that they so rightfully deserve?
Madam Chair, I would be happy to have those conversations and to help tribes not have to endure the hassle and the expense of that are imposed by some of these companies that they deal with.
Well, and Mr. Osceola, Chairman Osceola, I've got a couple questions for you. Your testimony detailed how uncertain it was to work with title insurance lenders without the certainty of the tribe having Non-Intercourse Act waiver legislation signed into law. Do you know why the one title insurer took the risk of insuring title? And did they have a different understanding than the other title companies?
We did what we could to try to get them to understand the law, but I think the question that is raised is that there are so many other lending agencies that weren't up to speed as Secretary Newland has mentioned, that's the challenges that we all face as tribes. That maybe one might understand how it works, but not all understand how it works, and they're not keeping up with legislation. And I think that's a challenge, is that they're not willing to go and look at the legislation. And yes, it calls for additional fees and attorney fees and closing fees, because we had to try to educate them. And if we didn't do a good job, or they didn't do a good job of understanding what that education process was from our side or their side, then they deny it, and we're not able to move forward. And then we were able to find just that one company out of so many that we looked for. And it was not only in the state of Florida, but all across the country, just to find somebody in the local areas where we were buying real estate. So the challenges are faced not only by us, but by the tribes. And I understand the concerns raised by the department. But again, we are all moving fast in a world that is growing way beyond us. So we need to keep up as tribes. And this is one of the ways that we believe at the Seminole Tribe that we can advance ourselves even further if we can get this removed, if not amended, as you're so speaking with Secretary Newland, on how we can make it easier for everybody. Because what we've experienced since 2021 and that law being introduced and passed, we have experienced a lot easier path to acquiring lands off reservation.
Well, in 1532 is quite simple and straightforward. And I would assume that our title insurance companies could read that and understand it, and perhaps that just takes away one of those moving parts that we don't need. And I have a question for Vice Chairman Williams. You mentioned in your remarks that a title company is refusing to provide title insurance to the company that wants to purchase your public golf course. They are telling you that the Interior Department needs to issue a legal opinion stating that this sale is not subject to the Non-Intercourse Act. Is the Department of Interior being cooperative in responding to your request for this legal opinion?
Yes, Madam Chair. They have been very responsive, and we are in the process of getting a legal opinion that our golf course property is not subject to the Non-Intercourse Act. However, this is the problem becomes more widespread. The department could be overwhelmed with these types of requests. It makes more sense for Congress to act and address this problem up front. HR 1532 does that.
Okay.